Outside the Supreme Court, the crowd isn't just about curiosity. It reflects a nation grappling with the structure of its own authority. The courtroom is filled with originalists, judges focused on statutory precision, but what's unfolding isn't only a legal argument, it's a stress test on institutional boundaries. John Sauer, representing the Trump administration, is trying to stretch presidential trade authority beyond a clear legislative grant. In business, we call this overreach. When there's no defined margin, risk becomes systemic. Investors, citizens, and courts all depend on defined limits. Ambiguity breeds volatility. And volatility, when injected into governance, can be far more dangerous than in any financial market. Justice Amy Coney Barrett, known for her strict reading of the law, challenged Sauer directly. She asked where in the statutory record such tariff powers were ever granted. That wasn't a rhetorical jab. It was a reminder that power must be grounded in language, not ambition. Another justice noted the danger of letting executive taxation override congressional authority. In a republic, separation of powers isn't ceremonial, it's operational. When a single office absorbs multiple functions, predictability evaporates. That predictability underwrites legal confidence, which supports economic trust. Strip that away, and you weaken more than governance. You shake the foundation of every investment tied to long-term institutional certainty. Sauer defended his case by framing these tariffs as regulatory, falling under foreign affairs, but inherent power must still answer to the Constitution. In finance, no firm succeeds by operating outside oversight. Why should government? If a president can set trade barriers without Congress, he may soon set fiscal rules without Congress. That's not speculation, it's sequence. When checks vanish, ambition expands. And when markets detect instability in how law is enforced, they reprice not just risk, but the reliability of the entire system. Judicial pushback here isn't partisan, it's preservation. Without that, the legal framework that safeguards economic confidence begins to unravel. When a sitting president calls for the arrest and impeachment of a federal judge, we're not dealing with political theater anymore. We're confronting a direct challenge to the rule of law. This isn't a tweet, this isn't a press conference slip. It's a coordinated move against Judge James Boasberg using formal impeachment filings, not just outrage. Congressman Brandon Gill filed the articles. The ink on that paper isn't just legal text. It's precedent in motion. And if you believe in institutions, as investors and citizens must, this is not how stability is built. Boasberg didn't commit a crime. He enforced legal process. He halted mass deportation orders and authorized subpoenas based on prosecutorial evidence. That's judicial function, not defiance. But when the executive branch punishes rulings it doesn't like, we're no longer talking about governance. We're talking about consolidation of power. In business, retaliation signals weakness. In government, it signals erosion. The Constitution was designed to absorb pressure, not personalize it. But this is not pressure. This is power weaponized against independence. What we're watching is an attempt to convert the judiciary into an extension of the executive. That kind of erosion doesn't happen overnight. It creeps in through targeted attacks, loyalty tests, and public intimidation. Over time, it chills not just rulings, but the willingness to uphold principle. In my world, integrity compounds. But so does fear. And fear, once embedded in legal institutions, devalues every other check in the system. Judges are not instruments. They're safeguards. If you break them, you're not leading a nation. You're managing a narrative. Let's set aside all the noise for a moment. This isn't about headlines. It's about structure. Markets don't function on political drama. They function on rules, trust, and credibility. When trust erodes in one institution, say the courts, it doesn't stay contained. It ripples into confidence in regulation, property rights, and contract enforcement. That's when capital looks elsewhere. Because no investor places money in a system where power overrides due process. Not for long, anyway. Sauer tried to anchor Trump's tariff authority in historical precedent, citing an early version of the statute used by Nixon. But invoking Nixon in 2025 is like using a rotary phone to explain a smartphone. Context matters. What was once regulatory necessity can't justify present-day overreach. The court pushed back, as they should. Meanwhile, Trump took to social media, branding Judge Boasberg with personal insults. That wasn't critique. That was calculated messaging designed to delegitimize the bench before the public could even hear the facts. The attacks didn't stop in March. They snowballed into a campaign. Judge Boasberg became a target not for misconduct, but for doing what judges are supposed to do, authorize legal process under seal. Now, Trump's allies in the House have filed impeachment papers claiming Boasberg abused his power by approving subpoenas tied to something called the Arctic Frost investigation. But let's be clear, classified or not, sealed subpoenas are standard in sensitive cases. If procedure becomes punishable, then discretion disappears. And without judicial discretion, what's left is not law. It's permission. Trump's allies claim Judge Boasberg is targeting conservatives for political gain. But that argument ignores the judicial process itself. Subpoenas aren't issued based on ideology. They follow a review of submitted evidence and legal criteria. Judges aren't political actors. They're gatekeepers of process. When they issue a subpoena, it means the law requires scrutiny, not that personal views are in play. Undermining that distinction erodes the line between legal duty and political loyalty. And once blurred, that line rarely recovers. Boasberg acted within his role, reviewing facts, applying standards, and authorizing a legal instrument. Now, for doing exactly that, he's facing impeachment. Worse, the situation has escalated. Under Attorney General Pam Bondi, the Justice Department attempted to prosecute a state judge for obstruction based solely on a ruling. That's not a disagreement over law. That's the federal government using prosecution to penalize independence. It's not just a constitutional threat. It's a cultural signal to every judge. Discretion is now dangerous. Bondi's public threats stating, "We will prosecute you, we will find you," mark a departure from legal principle into intimidation politics. Judges are meant to interpret the law without fear of personal consequence. Once retaliation enters the courtroom, impartiality exits. In markets, we call that corruption of the decision-making process. The judiciary operates on trust the same way credit does. When that trust is replaced with fear, what follows isn't law, it's compliance. And compliance under threat is the beginning of institutional decay. Trump is reshaping the judicial landscape through pressure, not policy. When judges begin to consider personal risks before applying the law, you've introduced a distortion far greater than any legislative overreach. This isn't simply about one ruling or one judge. It's about a chilling precedent where every decision carries the threat of retribution. In finance, that's the equivalent of a market run based on fear, not fundamentals. And once fear replaces judgment in any system, integrity collapses from the inside out. Chief Justice John Roberts, who rarely steps into public debates, took the extraordinary step of issuing a statement. He didn't just defend Boasberg, he defended the framework itself. For over 200 years, impeachment was reserved for gross misconduct, not legal disagreements. Roberts reminded the nation that judicial decisions, right or wrong, go through appellate courts, not political punishment. That process isn't a formality, it's a safeguard. Without it, the rule of law becomes the rule of force. Appeals are the constitutional path for resolving disputes, not impeachment trials driven by partisan grievance. When the Chief Justice speaks, it's not noise, it's a signal. Roberts didn't need to name names. His message was unmistakable. Weaponizing impeachment against judges for legal interpretations is corrosive. It not only threatens independence, but endangers long-term stability. In the markets, we call that institutional risk. And once confidence erodes in one branch, the rest will follow. Chief justices don't usually enter political storms. Their silence is deliberate, a symbol of the judiciary's insulation from emotion. But Roberts saw something deeper, a crack forming in the foundation. The impeachment push wasn't about misconduct, it was about preference. And when legal rulings become punishable by political actors, independence dies quietly, not through speeches, but through silence from those too afraid to rule. If judges begin to second-guess their rulings based on political consequence, you no longer have a court. You have a compliance board. Legal clarity disappears. Fear becomes the new filter in that environment. No one will challenge executive overreach, not because it's legal, but because it's safer. That's not democracy. That's a warning label for collapse. And once it starts, it doesn't stop at one bench. It spreads through every chamber tied to public trust. This erosion isn't incidental, it's intentional. The goal is controlled judicial, legislative, institutional, and it's arriving at a time when legal scrutiny is mounting. Trump is under multiple investigations. His policies have been blocked in courtrooms across the country: immigration, tariffs, deportation. Each check on his power reinforces why courts must stand apart. But when power feels threatened, it doesn't seek balance, it seeks obedience. That's when independence becomes the target. Each time the courts reject his agenda, Trump doesn't respond with legal arguments, he responds with personal attacks. That's not a political style. It's a deliberate strategy to discredit independent judgment. But with Judge Boasberg, it's escalated into a structural assault. He's not just criticizing, he's attempting removal. And if successful, that sends a chilling directive to every federal judge. Loyalty trumps law. That's not just a political shift. That's institutional destabilization. In any system, government or markets, when fear replaces integrity, collapse becomes contagious. This is the essence of authoritarian drift, replacing legal boundaries with personal consequence. When leaders make examples out of neutral arbiters, the message is loud and simple: resist and you're punished. That's not how stable democracies work. It's how fragile ones fall. The judiciary's role isn't to serve personalities, it exists to restrain them. When courts are bent to executive will, you don't just lose balance, you lose trust. And in both governance and investing, trust is the first asset to vanish and the hardest to rebuild. Let's step back from the emotion and examine the facts. Judge Boasberg, appointed in 2011 by President Obama, serves in Washington, D.C. That alone has turned him into a political target for those who equate party affiliation with bias. But his record shows a judge who upholds law, not ideology. The articles of impeachment ignore legal standards and instead focus on affiliations. That's a red flag. Because when impeachment becomes about optics, not actions, it stops being oversight and becomes leverage. And any system that turns oversight into leverage is already in decline. Judge Boasberg isn't known for theatrics. He's known for structure applying law with discipline, not ideology. His docket includes high-stakes national security cases and, more recently, legal matters involving the Trump administration. What triggered this crisis wasn't personal opinion, it was legal restraint. He blocked specific executive orders that overstepped procedural limits. And that act, measured, temporary, and grounded in due process, ignited the backlash. Because in this climate, even following the rules can make you a target. The administration moved forward with mass deportations under emergency authority. Boasberg paused it, not permanently, but long enough to ask whether basic constitutional protections were being bypassed. That wasn't resistance, that was risk management. In finance, you don't greenlight billions without due diligence. In government, you don't remove people from the country without legal clarity. His ruling was an institutional break, not to stop the engine, but to keep it from crashing into the Constitution. What escalated the tension further was his role in authorizing subpoenas tied to a classified probe now known as Arctic Frost. While details remain under seal, reporting points to possible obstruction and misconduct by top officials. Boasberg reviewed the evidence, applied the standards, and signed off. That's what judges do. They weigh the law, not headlines, not popularity, and that independence is precisely why he's being targeted. Because unchecked power always fears principled restraint. When prosecutors approached Judge Boasberg, they didn't bring speculation. They brought documented evidence strong enough to establish probable cause. In confidential proceedings, standard in cases involving national security or high-level officials, he examined that material line by line. This wasn't a political act. It was procedural oversight. And when legal thresholds are met, the law doesn't ask who's being investigated. It simply moves forward. This is how responsible systems function. Prosecutors build a case, present justification, and request judicial authorization. Judges don't operate on feelings. They assess the law's requirements. Is the evidence sufficient? Are the demands narrowly framed? If yes, subpoenas are granted. If not, they're rejected. That structure protects both individual rights and the public interest. Undermining it for political reasons puts every future investigation, left or right, at risk of collapse. Judge Boasberg approved the subpoenas because the law supported them. They weren't arbitrary. They were constrained by standards reviewed under seal and aligned with precedent. But the moment those subpoenas touched a powerful political figure, the story changed. It wasn't about facts anymore. It became a narrative of persecution. That shift from legal scrutiny to political spin is where the real danger begins. Because once process is rebranded as partisanship, the entire justice system becomes a partisan target. There's been a coordinated push to paint Judge Boasberg as a political actor, accusing him of authorizing secret subpoenas without merit and claiming he's part of a so-called deep state. But here's the reality. Grand jury proceedings are closed for a reason. They're structured to protect the process, not to hide intent. The subpoenas were issued after legal standards were met, not because of who the targets were, but because the law required it. Allegations without evidence don't weaken the judge. They weaken public trust. This is how the legal system works when it functions correctly. Evidence is reviewed, procedures are followed. But when powerful figures dislike where the facts lead, they reframe legality as partisanship. That's not a legal defense. It's a PR strategy. The articles of impeachment filed by Congressman Gill don't dispute the process, they dispute the outcome. And when impeachment becomes a tool to counter rulings rather than misconduct, you're not defending democracy. You're dismantling it. The accusation now is that Boasberg weaponized the judiciary. But let's be precise. Judges don't authorize subpoenas to make political statements. They do it because statutes require it when probable cause exists. Removal from the bench is not supposed to be a policy dispute. It's a remedy for corruption, not conflict. If that threshold is lowered, every judge who rules against political power becomes a liability. And when judicial liability is tied to political survival, constitutional balance is no longer theoretical. It's broken. Disagreeing with a president is not grounds for impeachment. It never has been. In a functioning democracy, rulings are challenged through appeals, not removed by retaliation. Even if Judge Boasberg had misinterpreted the law, and there's no sign he did, there's a structured appellate system designed for correction. But this push to impeach him for authorizing lawful subpoenas amounts to an ultimatum rule for the president or lose your job. That's not law, that's leverage. What we're witnessing is not the application of justice. It's a demand for loyalty under pressure. That's a dangerous place to govern from. Even within conservative ranks, unease is growing. Chief Justice Roberts, a George W. Bush appointee known for his restraint, recognized the threat early. His public intervention wasn't casual, it was calculated. In rare moments like this, silence becomes complicity, and Roberts understood that. He's not aligned with liberal courts or partisan activism. His legacy is built on judicial conservatism. But this moment crossed a line too fundamental to ignore. His statement, though measured, carried a direct warning. Impeachment is not a substitute for judicial review. There are legal mechanisms for contesting decisions. Undermining that process by punishing judges creates an environment of fear, not fairness. And when fairness erodes, the foundation of trust goes with it. If impeachment becomes a tool to punish judges for doing their jobs, We're no longer operating under checks and balances. We're replacing law with personal dominance. That undermines the very architecture the Constitution was built on. When the judiciary is forced to align with political whims, independence vanishes. And when independence vanishes, trust in outcomes disappears right behind it. Systems don't collapse from one event, they decay when boundaries are quietly erased. This isn't about legal interpretation anymore, it's about personal allegiance. In Trump's world, judges are either allies or enemies. Prosecutors who pursue him are conspirators. Those who target his critics are protectors. That framework isn't just dangerous, it's corrosive. It teaches institutions to respond not to rules, but to rewards. Now, with Attorney General Pam Bondi in place, the Justice Department is shifting from neutral enforcer to political instrument. That shift isn't invisible, it's loud and deliberate. When the nation's top law enforcement officer publicly threatens judges with prosecution, the message isn't subtle, it's systemic. Bondi's statements didn't just challenge individual decisions, they challenged judicial legitimacy itself. The attempt to criminally charge a state judge for a courtroom ruling shows how far this new doctrine of intimidation is reached. In investing, we call that signaling. And the signal here is simple: rule against power and risk your career. That's not enforcement, that's coercion disguised as law. In April, the Department of Justice, under Trump's direction, attempted something unprecedented. It pursued criminal charges against a state judge for issuing a ruling that didn't align with federal preferences. The legal reasoning? That the judge obstructed justice by interpreting the law in a way that slowed down federal agents. That's not obstruction, that's adjudication. State courts routinely make decisions that influence federal outcomes. That's not a loophole. It's the essence of shared governance. This is how a federalist system is designed to work. When legal bodies disagree, there are channels appeals, federal challenges, jurisdictional reviews, but you don't criminalize judicial disagreement. You don't prosecute someone for applying the law in good faith. The very fact that such charges were drafted sends a message loud and clear to every judge watching. Your independence is conditional now. Conditional on obedience, not justice. And if that becomes normal, we're not just changing rules. We're rewriting the relationship between government and the courts. Judges will begin to rule not from conviction, but from caution. They'll ask what the White House expects, not what the Constitution requires. And when that happens, trials involving presidential abuse or overreach will lose legitimacy. Because in a system where verdicts are shaped by fear, justice doesn't disappear overnight. It fades case by case until all that's left is performance. What we're seeing here isn't just political overreach, it's a systemic rupture. When a president positions himself above legal challenge, the foundation of constitutional democracy weakens. This isn't about one judge. It's about reshaping the entire balance of power. The articles of impeachment against Boasberg aren't likely to succeed in removing him, but they succeed in something else, creating fear. And fear, once introduced into a judicial system, doesn't stay contained. Yes, the House may have the votes if party loyalty eclipses constitutional duty, but conviction in the Senate would require a 2/3 majority, something far less likely. There are still senators, even among Republicans, who grasp the deeper implications. They know this isn't about a legal mistake. It's about preserving the space where judges can operate without political chains. That space is fragile, and once fractured, it rarely recovers. The real strategy isn't legal, it's psychological. This isn't about removing Judge Boasberg. It's about broadcasting a threat, clear and intentional. Cross the line, and the machine comes for you. Public humiliation, legislative punishment, weaponized investigations. These aren't tactics of governance, they're tactics of dominance. And when judges rule from fear rather than principle, it's not just the law that's compromised, it's every outcome tied to it. Even when these intimidation tactics fail to remove a judge, they rarely leave without impact. The real goal is deterrence. Make one judge suffer, and others will think twice before applying the law against political power. It's a strategy built not on law, but on exhaustion, grinding down those who uphold the rules until silence feels safer than duty. And unfortunately, that approach has worked in other arenas. Prosecutors and regulators have walked away, not because the facts changed, but because the pressure became unbearable. The system was designed with guardrails to prevent this. Federal judges are given life tenure. Their pay cannot be cut. Those protections aren't luxuries. They're safeguards so judges can act on principle rather than popularity. When the law demands an uncomfortable ruling, they're expected to deliver it without fear. But fear, as we've seen in markets and governance alike, is a powerful disruptor. It turns strong institutions brittle. And when enough people decide the personal cost is too high, you don't need to rewrite the law, you just need to chill its application. What we're witnessing is a test not just of legal theory, but of institutional resilience. Can lifetime tenure hold when the environment becomes politically radioactive? Can courts remain independent when retaliation becomes routine? This isn't just a story for law students, it matters to everyone. Because if judges can be bent, the rules that protect regular people bend with them. And once the public loses faith that the law applies equally, the social contract begins to break, not with a bang, but with a whisper of resignation. Judicial independence isn't just a legal theory, it's a cornerstone of every free economy and functioning democracy. Without it, contracts mean less, rights become conditional, and decisions bend to pressure instead of principle. When citizens challenge power, the courts are where fairness is tested. But that only works if judges answer to the law, not the executive branch. The moment they shift loyalty from statutes to survival, that test becomes rigged and trust unravels. In authoritarian systems, the judiciary isn't a check, it's an accessory. It exists to validate decisions made elsewhere, not to question them. That's why an independent bench matters. It protects people from overreach. If a judge can be punished for applying the law, then every legal proceeding becomes theater. People show up, but they already know the outcome. And when that happens, the courtroom no longer belongs to the Constitution, it belongs to the Crown. That's the direction we're drifting toward. Targeted attacks on judges, especially for rulings grounded in law, don't just impact the individual on the bench. They send signals. If impeachment or prosecution becomes the price for doing your job, the smart move is to stay quiet. Over time, rulings start reflecting risk calculations, not legal reasoning. And that shift doesn't just affect high-profile political cases. It bleeds into every corner of the justice system, where silence becomes survival. This doesn't just impact one courtroom. It sends a ripple across the entire judiciary. Judges observe what happens to their peers. If they see careers dismantled for ruling according to the law, not politics, they begin adjusting their behavior, quietly, subtly. Over time, the legal system stops being about what's right and starts revolving around what's safe. That's how pressure compounds. Not instantly, but predictably, like compound interest working in reverse. Let's be clear, there's a legitimate constitutional mechanism for removing federal judges. It's not about disagreement, it's about documented wrongdoing. Federal judges are granted lifetime tenure with one key condition: good behavior. That standard exists to preserve independence, not immunity. When that line is crossed through corruption or criminal conduct, removal becomes not only appropriate but necessary. Historically, the bar for judicial impeachment has remained high for a reason. Since the founding of this country, only 15 federal judges have faced impeachment. Of those, just 8 were actually removed. Each case involved tangible violations, bribery, fraud, abuse. We're talking about acts that erode the very trust the courts are built on. That's the threshold. Not discomfort, not dissent, but clear, provable misconduct that disqualifies someone from sitting in judgment of others. Historically, impeachment has served its intended role to remove judges who crossed ethical or legal lines, judges who accepted bribes, committed crimes, or abused their office. And in those cases, the system held, accountability was enforced, but the independence of honest judges remained intact. What's happening with Boasberg doesn't resemble that. There's no charge of corruption, no allegation of misconduct, just political dissatisfaction with decisions rooted in law. He's not accused of fraud. He hasn't violated ethical codes. His offense is following procedure, halting deportations based on due process concerns, and approving subpoenas supported by legal evidence. Those aren't mistakes. They're responsibilities. Judges are granted protection precisely so they can act without fear of retaliation. If every ruling becomes a referendum on political loyalty, the bench stops being a forum of law and turns into a stage for power plays. Judicial immunity isn't about shielding wrongdoing. It's about insulating judgment. It ensures that decisions, even unpopular ones, are made without the threat of personal consequence. Disagreeing with a ruling isn't grounds for removal. That's why we have appeals. But when impeachment is used to punish legal reasoning, it stops being oversight. It becomes enforcement. And when power uses enforcement to mold outcomes, we're not talking about justice anymore. We're talking about control. It's astonishing that we even need to revisit this. These aren't advanced theories. They're the basics: separation of powers, judicial independence, institutional checks. These are the cornerstones of American governance. If those principles become optional, everything else from contracts to civil rights becomes negotiable. The debate here isn't about nuance. It's about whether the legal system serves the Constitution or bends to political convenience. Trump treats the judiciary not as a branch of government, but as a barrier to be removed. And part of the problem is that many in his base have been conditioned to view judges as enemies of democracy whenever they uphold constitutional limits. That distortion didn't happen overnight. It's the result of years of rhetoric where disagreement equals disloyalty. But there's a world of difference between questioning judicial philosophy and dismantling judicial independence. Now, that distortion is policy. It's no longer about debate, it's about removal. When judges are seen as threats simply for doing their jobs, democracy moves from disagreement to discipline. And that puts every lawmaker in a bind. Republican members of Congress know the stakes. They can back impeachment and appease their base, or they can uphold the Constitution and absorb the backlash. One path serves politics. The other protects the republic. Many House Republicans may move forward with impeachment not because they believe in it, but because they fear political fallout. In today's landscape, the price of independence can be a primary challenge. That's a distortion of leadership. When elected officials vote out of self-preservation rather than constitutional judgment, the system starts to bend inward. The House reflects the volatility of short terms and high-stakes loyalty. But the Senate was designed to be different, slow, steady, and grounded in long-term perspective. If this reaches the Senate, there's a strong possibility that cooler heads will prevail, not out of affection for Boasberg or agreement with his rulings, but out of respect for institutional integrity. Senators understand that impeaching a judge for following legal standards opens a door that future leaders of any party could walk through. Once judicial decisions become impeachable offenses, the line between law and politics collapses. And when that happens, the rule book becomes a scoreboard. Democrats face their own challenge. While opposing the impeachment is expected, how they oppose it matters. If their defense turns into a partisan clash, it risks forcing Republican senators back into their corners. A response grounded in constitutional principle, not party identity, is far more effective. Because the moment this becomes a red versus blue battle, the stakes shift. And judges, along with the entire judicial branch, become just another casualty in a game of political survival. For Democrats, the smart path isn't just to oppose impeachment, it's to elevate the argument beyond party lines. This isn't about defending one judge. It's about defending the idea that judicial power must remain insulated from executive retaliation. By referencing voices from across the political spectrum, former Republican officials, conservative jurists, the message becomes stronger. The principle here isn't partisan, it's institutional survival. And if you lose that, you don't lose a debate, you lose the foundation. If Trump succeeds either in removing Boasberg or in making judges too intimidated to rule independently, the ripple effects won't be loud. They'll be quiet, procedural, and devastating. Each case involving executive authority will begin with a predetermined hesitation. Judges will ask not what the law demands, but what the political cost will be. And when outcomes start reflecting fear instead of principle, power consolidates slowly but thoroughly. Unchecked, this trajectory leads to executive control with no institutional brakes. Immigration policy becomes unilateral. Economic decisions like tariffs bypass legal challenge. Even criminal prosecution becomes a tool of vengeance, not justice. Courts are no longer referees, they're removed from the field entirely. And when enforcement depends on courage rather than rules, what's left is not governance, it's command. When a leader begins reshaping the justice system to shield themselves from scrutiny, we're no longer talking about democracy, we're talking about control. That kind of governance isn't bound by rules. It's guided by appetite. And when the president becomes immune to judicial checks, you're not building a stronger executive, you're erasing the lines that separate free society from managed obedience. The world sees that. Global markets notice. Investors, allies, and adversaries alike read those signals clearly, and they adjust their expectations of America accordingly. You see, one of the most valuable assets America holds isn't a currency or a defense system. It's credibility, the trust that our legal institutions are impartial, our courts apolitical. But when we begin removing judges simply for decisions that displease the president, we squander that trust. We begin to resemble the very governments we once cautioned others about. That devaluation isn't just ethical, it's geopolitical. It weakens our leverage abroad and dilutes our standing in the global rule of law conversation. And remember, political power doesn't stay in one set of hands forever. The tactics you normalize today become tools your opponents inherit tomorrow. If Trump sets the tone that judges are to be intimidated or punished, a future president, Democrat or otherwise, might follow the same playbook. That's not just dangerous, that's unsustainable. It plants a seed of retaliation at the heart of governance, where each administration feels entitled to weaponize the law instead of uphold it. That's how institutions fracture from within, not from outside attacks. Once you permit a president to use impeachment as a stick against judges who merely apply the law, you've crossed into territory where precedent becomes poison. If one party begins punishing judges for ideological reasons, the other won't hesitate to retaliate the next time they hold power. Before long, we're not operating a justice system, we're running a political casino where court rulings swing with election cycles instead of legal merit. And when you gamble with institutions like that, eventually the House, meaning the Constitution, loses. If we want to preserve any semblance of judicial credibility, that slope has to be sealed off now decisively and without loopholes. The principle must be clear. Rulings you disagree with aren't grounds for impeachment. That idea isn't just inconvenient, it's unconstitutional. What we're watching with Trump's pressure campaign on Judge Boasberg isn't about one judge. It's about whether the judiciary still serves the law or bends to executive will. And that's not a policy debate, that's a foundational test. Let's be honest, this isn't born from concern about constitutional order. This is a reflex of self-preservation by someone cornered by lawful scrutiny. Trump isn't challenging the system because it's broken. He's attacking it because for once it's working. And Representative Gates' articles of impeachment, they're not legal instruments. They're warning shots sent to chill judges nationwide and signal that fidelity to the law now comes with a political price tag. That's not governance. That's coercion dressed as procedure. When institutions are under attack, words alone won't hold the line. Chief Justice Roberts issued a statement, yes, but in times like these, it's not the remarks that matter, it's the response. We're not debating policy preferences here. We're deciding whether an entire branch of government still functions independently. And that burden now rests squarely on Congress, especially those in the Senate who took an oath not to a man, but to a framework of law that predates all of us. This is not some procedural squabble in the background. It's the alarm bell of a constitutional unraveling. If judges start to serve the presidency instead of the law, you no longer have co-equal branches. You have a hierarchy with one man at the top. And make no mistake, markets don't thrive in systems like that. Neither does justice. What we choose to tolerate in the coming weeks will echo in every ruling, every courtroom, every future administration. We're not just watching an impeachment, we're watching America decide what kind of country it wants to be.